Judge Knapp, thanks for stopping by. I do have a question, though. I can't quite figure out from what you've been saying if it's your belief that a conviction is required in order for Section 3 of the 14th Amendment to be applicable for someone who's running for President of the United States. Just curious if you could clear that up.
Great question, Di, and thank you for asking it. I want the audience to know that you are a lawyer, and you obviously have looked at these things as a lot of lawyers have not. So the 14th Amendment was written in the aftermath of the war between the states and ratified in 1868. A lot of controversy involving its ratification. New Jersey and Ohio rescinded their ratifications after they sent them in, and Congress counted them anyway. Be that as it may, the 14th Amendment has been part of the Constitution indisputably since 1868. Section 3 of the 14th Amendment, as Di so properly points out, says that no person shall be an officer of the United States who, having sworn an oath of allegiance to the United States, engaged in or aided in and abetted an insurrection. It's clear that that was written at the time to keep former Confederate soldiers and officials of Confederate governments from re-entering the Union of the United States. I say re-entering. A lot of them were members of Congress and senators, and nearly all the soldiers in the Confederacy had at one point been soldiers in the Union Army, even though we didn't have a standing army at the time. Many of them were graduates of West Point and Annapolis. So along comes two legal scholars, both members of the Federalist Society, both self-professed conservative Republicans, with a mountain of research. And the research shows that in the years since 1868, people running elections, typically the Secretary of State of a state, on their own, could remove people from the ballot who the secretaries of state believed had engaged in an insurrection. They didn't require the niceties of due process. Of course, due process didn't really mature until we got into the 20th century. Due process, which is in the Fifth Amendment, cannot have been tampered by the 14th Amendment, or we wouldn't have a country. Due process says when the government wants to take away life, liberty, or property, it can only do so by a jury trial. So does Donald Trump have the liberty to run for the presidency of the United States? Yes, he does, because he meets the basic requirements of the Constitution. He's lived in the United States for at least 14 years before he wants to run for office. He was born in the United States, and he's over the age of 35. Can then a bureaucrat, a state secretary of state, whether it's New Jersey or New Hampshire or Colorado, just strike his name from the ballot on the basis of what the bureaucrat thinks Donald Trump has done, or must there be some proof as to what he's done? It's clear that there must be proof, even though this law review article, which is 126 pages in length, pretty good size even by law review article standards, and this research that these two professors did, which is exhaustive, reproduces literally hundreds and hundreds of instances in which bureaucrats struck the names of those from the ballot whom the bureaucrats believed had aided or abetted the insurrection, as they call it, of the war between the states. Put aside whether it was an insurrection or a secession, the 14th Amendment was obviously referring to that war, which most people call the Civil War. It is clear, in my view, that if the Constitution means anything, if the Fifth Amendment means anything, Di, and I thank you for this great question, it means that due process still stands. So Donald Trump cannot lose the right to run for president unless and until he's convicted of a crime of insurrection. Interestingly, in the two indictments against him involving January 6th, one by a federal grand jury in Washington and one by a state grand jury in Atlanta, Georgia, neither accuses him of being involved in or aiding an insurrection. So I can safely say, even if he is convicted of everything with which he's charged, involving January 6th, that still wouldn't be enough to keep him off the ballot. I'm giving you this opinion as a purist and a legal scholar, not as someone who has an opinion on whether or not he's qualified to be president, and not on someone who has an opinion on whether or not it is wise for him to be president, but just someone who has a scholarly and educated opinion on whether or not he qualifies to run for president. And under the qualifications clause in the Constitution and in the 14th Amendment, in my opinion, he does. I hope that helps, Di. All the best.